And a very good day to you all. Welcome to the Wall Street Blockchain Alliance's Call the Lawyers podcast, episode number 2. My name is Ron Quarant, and I'm privileged to serve as chairman of the board of the Wall Street Blockchain Alliance. Let me start with a little bit of a disclaimer. This podcast is not meant to be legal or professional advice. It is strictly for information purposes and educational purposes only. And with that, let me welcome our guests, Mr. Kenneth Hertzinger and Mr. Ed Eisert from Oric, and I'm sure it's a much longer name than just Oric. So Ken, you want to say hello and kick us off?
I will, and in the modern age of all of us trying to work in the COVID crisis, you might hear my dog barking. She was just going off, so just my own little disclaimer. So my name is Ken Hertzinger. I'm a partner with Oric, Harrington and Sutcliffe. I work out of our San Francisco office. A little bit about my background. I started my career as a SEC enforcement attorney about 20 some odd years ago. And I primarily SEC, in the SEC space. So SEC enforcement actions and securities class actions. And I got into the crypto blockchain space back in around early 2017 when the SEC first started to take an interest in the space, and have been working on any number of different cases in the space, serving clients in various different SEC investigations and securities class actions.
Great. And Mr. Eisert?
Yes, hi everybody. Yes, I am a senior counsel in Oric's New York office, and my practice is focused on the financial service industry, broadly writ, with an emphasis on new financial products and cuts across securities, regulatory, and related areas. I've been fortunate in my career to be able to work on cutting edge technology and financial services developments, and the distributed ledger technology is certainly an example of that, and it's been taking up a good deal of my time, basically over the same period that Ken referred to, and and I've had experience both in-house at major financial services firms as well as the product development side of other firms here in New York. And I'm delighted to be here and join you for this little fireside chat.
Well, thank you both. You're both members of our legal working group, and you're both stuck with talking to me on an ongoing basis as we look through a lot of the work streams that we've been talking about. One of the things that we discussed last week has been the case of Telegram, which continues to evolve and develop. Ken, if you could start, I just wanted to recap some of what's happened in the world of Telegram, particularly Judge Castell's ruling. Tell us your perspective on some of that, and then Ed, let's the three of us talk about the impact that some of that decision might have on the world of token offerings.
Yeah, and one thing that I think was sort of lost in the mix when the judge's order came out is that the story's not over yet. So the ruling that the judge ruled was actually only on the preliminary injunction itself, and he ruled that he would keep the status quo in place and keep the injunction in place. But I thought it was noteworthy the judge actually did not rule on the competing summary judgment motions that both the SEC and Telegram had filed. And from a procedural standpoint, I think that's important because the SEC had filed a summary judgment brief along with the injunction brief requesting full relief. In other words, that the judge find that they failed the Howey test and this was a violation. And had the judge decided to grant that, it would have been an absolute win sort of across the board, case over. He declined to rule on Telegram's brief, which would have granted them, a judgment. And then, as people probably read, shortly after the preliminary injunction order, Telegram appealed the case up to the Second Circuit. And in a matter of an injunction, you have an appeal as a matter of right. So that is now going to get, heard by the Second Circuit. So the story's not over yet, but the judge did render some, I think, noteworthy rulings for the industry. And it's interesting, kind of as a litigator, my high level takeaway is, sometimes bad facts make bad law. So, the facts in the Telegram case, I think are, unusual in that it was such a massive amount of money that was raised, $1.7 billion. The obviously the individuals involved and the name of the entity are high profile, likely why the SEC went into it. But there are also some factors and facts in the case that I think are distinguishable from a lot of other, industry participants. So for example, you probably noticed, those of you who've read the order, very, very little analysis of the decentralization prong. And that's because, Telegram, do not have a foundation or a decentralized entity at this point that will be running, the ultimate platform. And in fact, when the judge pressed Telegram's counsel about when and if that, that decentralized, sort of operating governance board would be put in place, Telegram's lawyers had to admit they couldn't guarantee it would ever be put in place. And so I think that's quite distinguishable from a lot of, our members' structures. And so I think that's a factor worth noting. And then second, on the, the sort of, offering piece, the judge did call out the fact that most, if not all, of the original SAFT investors were venture capital type funds. And in his view, the way he read the facts, the entire initial rounds of offerings were all with an eye towards resale, and that everyone had always contemplated that this was basically just a pre-offering to a public offering. Again, I think that's distinguishable. Now, all that being said, I think one of the most significant things to come out of the ruling is that the judge adopted the SEC's argument and basically conflated the pre-round sales, the SAF sales, with the secondary market sales, which have yet to occur, and basically conflated them and found it was one offering, one transaction. That has some pretty, significant potential implications for the marketplace. And frankly, my own personal view, I think the judge got it wrong. But again, based on the facts of this particular case, I think, it's the way he decided to rule, and we'll see how the Second Circuit goes. It has implications, I think, because I think many in the market, listening to SEC guidance, including Commissioner Pierce, have been under the understanding that if you follow the SEC's rules, you do an exempt offering, Reg D type offering, that is different and distinguishable from a later token issuance, and that later token issuance should be analyzed differently to determine whether or not those instruments are themselves securities. And the SEC and then the Judge Castell, essentially collapsed those two things, which again, I don't agree with the analysis, but be interested to see how this all plays out.
Ed, let's get your thoughts on the ruling as well. And then I want to push on a couple of items, Ken, that you mentioned as well. But Ed, what were your thoughts post-ruling?
Yeah, well, I think picking up on Ken's thoughts, I see the ruling moving away from the focus on decentralization as being the sine qua non indicia of there being or not being a securities issuance, and shifting attention, particularly at the hearing, to some focus on to what extent there have been undertakings, implicit, in the words of the SEC staff, implicit or explicit, of a promise to someone acquiring a token that they will in fact build a system, etc. And therefore there's a reasonable basis to rely on that, and that implicating the securities laws. I think we're, in that sense, maybe at an inflection point between focusing on ICOs and SAFs to dealing with some of the issues associated with secondary trading markets, particularly if the operator of the exchange was not acting directly as an underwriter for the issuer. In other words, a third-party exchange, in principle, no connection, no undertakings to the issuer, but just unrelated third parties executing on an exchange? Should at that point the securities laws be applicable? Is, I think, one of the next chapters to be told.
Interesting.
Yeah, it's a great observation. I was just going to say, I mean, if you follow the judge's reasoning, then theoretically, even those secondary market purchasers could potentially have liability. And again, this is one of the reasons why I think I don't agree with the judge's reasoning, and I think it was flawed, because if you follow it through to the next step in the logical reasoning, I agree with Ed, you would have potential liability for other actors beyond the issuer and even beyond the exchange, those trading in the underlying tokens.
Take that a step further, Ken, if you wouldn't mind. Those even beyond the exchange, what does that flow look like from that perspective? Who are we talking about?
So, according to the judge's order, the Telegram failed to carry its burden to show that it met an exemption to the registration requirements, at least at this stage. And primarily found that because he believed, based on the facts, that the intent was not that the securities would come to rest with the initial round of purchasers, that the intent was that, in fact, they would get distributed to the open market, and that therefore, as Ed was saying, they could meet the definition of underwriters, which courts have interpreted fairly broadly, and that the secondary market sales are themselves violations. And so theoretically, those individuals and entities buying those securities downstream on the secondary market could theoretically have aided and abetted Section 5 violations by the issuer and then by the SAFT primary holders who had bought them in the first instance and are now selling them in the secondary market. And again, I don't agree with the reasoning, but if you were to follow that reasoning downstream, it would lead with an absurd result that the investors that the SEC claims that they're protecting were buying in the secondary market, who aren't getting the access to public information as the SEC wants them to for a registered entity. Those individuals themselves, under the reasoning, would theoretically be liable for aiding and abetting a breach of the securities laws.
Right.
Go ahead, Ed.
Oh, I was just going to say I agree wholeheartedly with Ken's observation. And, when we kick these things around, I'm reminded, the 4 prongs of the Howey test. And in the case of ICOs or SAFs, the element of common enterprise, there be a common enterprise, has not featured prominently at all. It's basically been an assumption. But now when you start to look at secondary market transactions or, purchasers of tokens that were not initially getting them directly from the issuer, query, where's the common enterprise that's now governing the instrument when viewed from the perspective of an unrelated third party who's bought on an open exchange without prior commitments from an underwriter or the issuer.
Right. And it's interesting, I'm a non-attorney, and obviously our membership is, we have the legal working group, but a lot of our members are in financial services or in technology. And one of the things that I think the judge's ruling helped to shed a light on for them, not to make too deep a point of it, is this idea of intent and expectations in the purchase of these tokens, which for a long time, colleagues in the space or technologists thought was not relevant. And what the judge's ruling has said, and what the conversations that we've heard, is that that's something that needs to be kept top of mind when these things are launched. Is that right, Ken? I mean, from the perspective of going forward token offerings.
Well, I do think that because the judge has come out this way, and even though it's a preliminary injunction order, I do think people need to be cognizant of that. And for example, the industry members, our industry members, WSBA, should be thoughtful because, again, some of the entities, in fact, according to the order, all the entities that purchased in the SAF were venture capital firms.
Right.
So again, thinking through that logical connection, if those venture capital firms out there are investing in these tokens and their intent is to resell them at a profit downstream, Judge Castell is saying, yes, that actually matters, and that may render those tokens to be securities. I think that's a flawed logic. I don't read the law that way. I don't read Howie that way. But to your question, Ron, yeah, if I were them, I would talk to my lawyers about that, because it is something to be cognizant of, going forward based on this ruling. And they want to make sure, obviously, they're as compliant as they can be.
Right. So Telegram wasn't the only news in the space over the past several weeks. One of the things that we discussed at our last legal working group meeting, and I know both of you are looking at fairly extensively, has been a series, I think it's just short of a dozen class action lawsuits against token issuers. So Ed, do you want to start off kind of describing what happened in this space? I know a lot of my colleagues and a lot of our members in financial services and beyond are trying to wrap their heads around what this means, and I think it's fairly important for the ecosystem. And then Ken, if we could peel back the layers of specifics there, that'd be good as well. But Ed, did you want to kick off?
Yeah. Well, the cases, of course, there are 11 of them, and the fact patterns are similar but not identical. But I think based on, sharing ideas with Ken, I think we see the significance being that the exchanges that were involved in the financings were the subject of a lawsuit as well as the issuer, and these were ICOs, not SAFs, so more plain vanilla issues from a securities regulatory standpoint. But interestingly to me anyway, the complaints, I don't believe, making the case that there was, or raised this concept of decentralization or decentralization as being relevant to the securities analysis. Rather, they were seem to be focusing on the framework that the staff put out a year ago that mentions the element of implicit or explicit promises, and they seem to go. The plaintiffs seem to go off in that direction. But Ken, correct me if I'm wrong, but I don't know if these exchanges were truly third-party players, but rather they were acting, and plaintiffs could allege they were acting as part of a scheme of the issuers. Do I got that right?
So it's interesting. So with respect to the asset exchanges, I think, frankly, one of the defects in the complaints is they don't allege any specific conduct or activity as to the exchanges. They have sort of boilerplate allegations that the exchanges were operating as unregistered broker-dealers because they solicited sales, et cetera, et cetera, et cetera. But they literally just copied and pasted, the elements of Section 15A1 into the complaint. There's no specific facts alleging that they did this conduct. I agree. I think the most interesting takeaway, a couple of the most interesting takeaways. So there were 11 cases filed all on the same day, Friday, April 3rd, a couple of weeks ago. That I think is significant. The fact that the plaintiffs' firms that filed the cases are the same firms that filed the $1.4 billion Bitfinex and Tether case. They seem to be chiefly interested in this space. The same firm has a long track record for bringing big class actions and settling billion-dollar class actions. So to me, it was significant in that the plaintiffs' bar is taking a real interest in this space. I think we've seen the first wave of probably several to come of securities class actions that we've all been anticipating for much time. And then the other significant takeaway to me is what we've been talking about just now is the fact that they extended it beyond just ICO issuers, which is what we've seen in the past, and they've taken it to the exchanges. So there were 7 of the cases were against the issuers themselves, but then 4 were against the exchanges. And, that I think is a pretty significant move. And they are now out ahead of the SEC in my view. The SEC's brought only a couple of small cases. Token lock was probably the most, noteworthy one back in 2018. And in that case, to Ed's point, the SEC did allege very specifically, and what seemed to drive that order was that they said Token Lock was actually marketing the underlying tokens, not merely just taking commissions, but that they were actively out there promoting them. No such allegation like that is in these complaints. It's just basically, sort of tracking. But as an industry takeaway, I do think that to the extent more of these cases are filed, and even just these cases, it could have a chilling effect on the liquidity in the market, because these are some of the biggest exchanges in the space, biggest asset exchanges out there, and I think they and others, may start to get litigation gun shy, and that could have a chilling effect on some of our members' ability to actually, be able to get liquidity and circulate tokens to fuel their networks. And ironically, Commissioner Pierce's safe harbor actually encourages, market listings to do that very thing. So I think from an industry takeaway, anytime you see class actions and major liability, people start getting nervous. And if these exchanges start putting a lockdown on the ability to use their exchanges for token trading, that could have a ripple effect, back to the various different organizations trying to get up off the ground and get a network going.
Ken, on that point, some of us have been wondering, why did some of this class action effort take so long? It could have happened previously. Has the industry been waiting, or have litigants rather been waiting for an experienced class action firm to put these forward? And has that shifted what will happen in the future? Will people be more likely to engage class actions going forward in this space? And I think that alludes to some of what you just said. Why did this take so long?
I don't know. It's a good question. There have been a number of firms that have taken some interest in this space, but they aren't traditionally the larger class action firms. And, my guess is as good as yours. The only thing I could think is that I think that it's perhaps the reason it's starting now is that the industry is maturing. So, at the beginning, I'm not sure the plaintiffs bar frankly knew what to make of all these ICOs and thought perhaps it was a regulatory matter. But the market has matured quite a bit, and there are many of our members and clients and many participants now who've moved beyond sort of the ICO stage, the initial stage, and they're real operating entities with a real revenue and funds, and therefore make a more likely target for a class action suit. So that could be the case. I know D&O insurance has also developed. In the beginning, you could not get it. Now you can.
Yep.
And we know in our world, securities class actions, D&O insurance is necessary, but it's also a thing that could attract lawsuits because they know there's a policy and there's coverage. So, but those are just sort of my guesses. I don't know what took so long, but it does seem like there are larger, I'd say more well-organized plaintiffs firms now, entering the space.
Yep. Ed, before I move forward, did you want to add to that at all?
Yeah, just one further observation. I think, again, we're going to see refocus on secondary market trading. And it's tying back to the Howey test, the common enterprise theme. Query, when does the explicit or implicit promise of the issuer to build a system burn off? Because everyone recognizes that what, like a SAFT is, is a bundle of contractual undertakings and promises coupled with the token. At some point, you're someone who's buying in the marketplace as an individual, I would say, well, can they really be entitled to rely upon an implicit promise that was made to a direct purchaser? at some point, on my view, it's got to burn off. And the question is when and how. What do you look to reach that conclusion? I don't think that's received a lot of attention, and I think it's because the primary focus has been on the initial issuance, and as I mentioned before, it's sort of been assumed there's a common enterprise.
Great, thank you, Ed. So we're approaching kind of the end. These are usually our short form videos. Ed, let's stick with you for a second. These are trying times for all of us. I know many of us are kind of sheltered in place. How challenging is being a lawyer in the age of COVID and being sheltered in place? How's it affected your day-to-day?
Oh, well, that's a good question. It's hard to pin it down. I'll tell you one thing. I live in Midtown Manhattan, and when it comes to getting all the guidance, stay 6 feet away from people, the fact of the matter is, when I go out for a walk, I can't find anybody to steer clear of. That's
Wow.
a little bit of an exaggeration, but seriously, unless I'm into a supermarket, the streets are eerily quiet and light traffic. So it's not so bad, and I have no complaints really. I'm very fortunate in that regard.
Ken, you're on the West Coast. What's life as a lawyer on the West Coast? How have your days been going? A very nice office, as we chatted about before recording. How's it going for you?
So it's going well. I mean, most importantly, family, friends are safe and healthy. It's a unprecedented time and a lot of nervousness and uncertainty. And I think, on the transactional side, there are people wondering, okay, should we be moving forward with deals we contemplated or deals we might have done? I think, unfortunately, it's therefore having a pretty negative economic impact. On the litigation side, it's interesting. We, at Oric, and I know probably a number of other firms, have been able to adapt and put in place, pretty efficient plans, COVID response plans. So on a day-to-day, we're able to do virtually everything we could normally do. The one thing that's really impacted the litigation world is, one, the courts have slowed down dramatically and, are canceling trials, and, most hearings now are being taken on the papers. And then two, live interaction has been stopped. So depositions, SEC testimony, all of that type of activity just cannot occur. And so to me, that's the most interesting thing, is I've learned, to one extent, going forward, we can do a lot more remotely than we thought we could, but there are certain things that you just can't do unless you can get together in a room. and so, it's been an interesting learning experience coming at us. I guess we'll probably be more efficient going forward after this whole process. But it does make you realize that the system in our practice, what we do, just cannot function unless you're able to all get around and get in a room for a number of pretty significant events.
Yep, challenging time.
I would definitely echo that. I've been working on a closing that spanned the last 2 weeks, and despite the video conferencing, there are just some things that can't do as effectively, communicate as effectively by video.
Challenging times. We'll get through it. I never thought I'd live to see the day where the United States Supreme Court is taking virtual statements, if I remember seeing that the other day. Gentlemen, we're going to leave it there. Thank you so much. Be safe, be well, and thank you for being part of the Call the Lawyers podcast of the WSBA.
Yep. Thank you so much for having us, Ron.
Thanks, Ron.